Judge Newman, thank you so much for taking the time to meet with us today. And on behalf of the California Lawyers Association, I'm very pleased to present you with our 2018 Judicial Vanguard Award.
Oh my goodness, no, this is quite lovely. And thank you, thanks to you and to the association. I'm honored not just to be the recipient of this award, but to be in the company of the others who are receiving this award today as well. It's an honor for me to know that the work that we all do here is noticed on the West Coast as well.
Very much so.
Very much my appreciation to you for coming here and coming to Chambers to present it to me.
Oh, thank you.
It's quite lovely and elegant. Let me set it down.
Is it true that you were the first judge appointed directly to the newly created Federal Circuit?
Yes, it is. This goes back a long time. The Federal Circuit was not really a new court. At the time, it was a combination of two of the oldest courts in the nation, other than the Supreme Court, the Court of Customs and Patent Appeals with 5 judges, the Court of Claims with 7 judges, all very experienced in their fields. So when they were combined into the Federal Circuit, there wasn't really very much that was new. What was new was the transfer of the appeals of patent cases to be consolidated in one court. That was calculated to be about 12% of the total jurisdiction of the combined court, which was an essential aspect of the principle that it would not be a specialized court in any particular area, and certainly not in the area of patent appeals. And so the 12 judges started out. When one of the judges left, I wasn't the first person who was nominated to take his place. That was a man named Sherman Unger, who had been the general counsel of the Department of Commerce, but he died, unfortunately. And so I was nominated next, and that did make me the first new judge of this old court with a new name.
Fascinating. And with your background and experience in patent law is what you're known for, but are there other areas of intellectual property law that you find interesting?
Well, you know, they're all interesting. And my work in the private sector wasn't just patent law. The group that I was with the FMC Corporation, was responsible for really anything that involved technology, because of all of our lawyers had a technical background, which was unusual in corporate legal staffs. So we did the patent, trademark, copyright, trade secret work, as well as the technical aspects of the company's other interests, which included government contracts and employment law. I was thinking of the other major areas that the Federal Circuit was involved in when it was formed.
And when you were at FMC, in any of those other areas, did you find particularly interesting? The trademark, the trade secret, the copyright?
Well, they're all interesting in the abstract. And when you get to a dispute, to aspects that people are fighting about, that they haven't been able to resolve, where big bucks are involved, that really characterizes the work of a judge. They become particularly interesting. I
would imagine. Did your experience at FMC inform you or shape how you act as a judge, or your experience on the court?
I think it is the dominant aspect of how I work as a judge. Those 30 years in industry, as I learned how industry works, I should say how capitalism works as well, the need for profit, as I think of those who suggest that patents should be free to everybody, I can't help but wonder who is going to support the research and the development. and all else. So in all of the areas in which I work, certainly it's that industry experience which has a strong influence on how I think, how I see the law, and how I try and decide the cases.
Well, as practitioners, we all appreciate judges who have had some practical experience and have walked in our shoes before coming on the bench, so that's great. What advice do you have for advocates appearing before your court?
I would say the most important aspect is to be prepared, to be fully prepared. As an advocate on the appeal before us, you have 15 minutes per side. That isn't enough time to get deeply into anything, but it is an opportunity to point out, and this is how I see oral argument, for the advocacy to point out what they believe is their strongest case, the strongest aspect of what they've written, and for us as judges to pursue the points that perhaps were not so fully developed in the briefs, and sometimes we wonder why, whether it was a weakness in the case, whether there was something that might be explored. So often I hear the comment of, why did the judges pick on that peripheral issue? More likely than not, it was something that we didn't fully understand. We've read the briefs. We and our law clerks have delved very deeply into the issues that are presented to us on appeal, and we use the time in contrast with the way advocates use the time. We use the time to try and explore points that we think were set aside, that may have been weaknesses in the case, that may have been dominant, or that just were, in our view, more significant than the advocates or the trial judge thought. So to be prepared with everything, not only to know what's in the briefs and to know what's in the record that was provided to us, but also to know what was in the record at trial or before the tribunal that came before us, because these relate to areas that we, in trying to get it right, in trying to reach the right decision, use our share of your 15 minutes to explore.
That's interesting. So the court does use oral argument as an opportunity to inform itself on areas that it felt wasn't covered in the briefs or that it has questions about.
It's our only opportunity, and we see it that way, as our time, as well as the advocate's time.
That's great. How has the America Advance Act impacted your job as a judge?
Well, it's had an important practical impact on our workload. We now receive from the Patent Office under the America Advance Act about as many appeals as we receive from the district courts, several hundred a year. So it is a bump in our workload, not so much in our jurisdiction or not so much in the issues that we need to decide, except that we often find much more emphasis on the technological aspects of the issues in the cases that come from the Patent Trial and Appeal Board. In fact, if they aren't that fully developed, we may be inclined to send it back for further development, because our understanding of the purpose of this shift, this intervening tribunal in appeals from the Patent Office, is to look as deeply and as profoundly as is available at the technological issues. But it has, from a practical viewpoint, made a large bump in our workload, so that we're perhaps a little bit slower. We perhaps find it necessary to decide more cases without written opinion when we believe it was correctly decided at the trial level. And our other areas of jurisdiction as well are also squeezed. The initial plan that patent cases would be 12 to 15% of our workload has certainly been diverted. So including the appeals from the Patent Office, I think they're now about half of what we do.
Wow. That's significant.
It is a significant increase. I'm waiting. It's still been just a few years. I think the judgment as to whether this is the best way to handle the greatly increased emphasis and importance on technology in the United States is ideal, or whether there are even better ways of resolving issues, of getting it right at the threshold so that we don't have the negative influence of uncertainty that I'm told now pervades a lot of technology R&D in the private sector.
Any other recommendations for addressing that increased workload, other than having it more settled, earlier in the process?
I'm not sure yet. I'm thinking about it, and I certainly encourage all of you in the bar to give it your best thought and your best experience. As soon as I settle on some sort of recommendation, I'll be sure to let you know.
We would appreciate that. Thank you. What do you see as some of the attributes of a good judge?
Wisdom, persistence, wisdom, thoroughness, wisdom.
And where does some of that wisdom come from your perspective? Life experience, or?
Yes, it comes from life experience. The master plan of judges, most judges move into the judiciary after extensive life experience. And on our court, part of the plan, in fact, an essential condition of forming our court with the consolidation of appeals, was that it would not be a specialized court, that it would be diverse and bring diverse life experience to bear on these complex topics that had been very much the structure of our predecessor courts as well. And by putting those courts together to do as well as could be done in designing a judicial body to bring this breadth of experience. This may also account for some of our diverse viewpoints, but that too is part of the master plan, that by the time the judiciary is put together, that you don't have what they call the tunnel vision of limited life experience.
And has being located in Washington, D.C. impacted the court at all?
Yes. I suspect that most or all judges in the federal system have this same experience, but here we're very much aware constantly of the role of the judiciary in our federal structure and in our national structure. As we look out the windows of my chambers, we see the White House, and we see the monuments, and we see the park named for the Marquis de Lafayette, and we have this continuing reminder of our past, of the nation's history, and of the future, and of the role of the judiciary in the government structure.
It is stunning views, and it would be quite the perspective to be looking out after reading a brief and see the Washington Monument on your right.
Indeed.
Is being a judge ever boring?
Never. Never. That's really thanks to you, all of you, in this bar. And this, I think, is a particularly interesting time in the patent era because there's so much new technology. So much is happening in science and in the world that is changing. And the old rules don't really fit. They don't fit very well. we need to decipher, to think through what's best for the nation and how the law can adjust at the same time with the deepest respect for tradition and for the common law. And so it's not boring.
Well, certainly not as we as practitioners don't think so, but you're very right that it's the technology is moving so much faster than the law can keep up with sometimes. So it makes for some uncertainties that might be intellectually interesting, but our clients don't necessarily appreciate all the time.
Yes, of course.
Anything else you'd like to add about the award, or anything else you'd like to share with our audience who will be seeing this?
Well, I certainly want to add my appreciation to you for coming here to present the award. I wish I could be there with you. I'm particularly honored to be in the company of the others who you're recognizing, and this does give me a chance again to remind all of you in this bar that the future is in your hands, as well as the obligation, the responsibility to think through the issues that come to us and to get them right. But again, my thanks to you and to the association for this great honor.
Certainly, most well deserved. Thank you for your time, Judge.